The man you're looking at is Arthur J. Hirsch, the Nome Emeritus in Tennessee. Jay, we just came from the General Sessions Court of Judge Harris, and I want to ask you, what is it that you're proposing in your defense? You have a remarkable defense, Jay Hirsch, against traffic allegations. What is your thesis and your theory?
I have two affirmative defenses. The first one is that the statutory administrative remedy has not been exhausted. And until it's such, the statutes and case law shows that the courts do not have jurisdiction. Secondly, my second defense is that the citation is a forgery. The officer and the magistrate knowingly falsified the affidavit or the sworn statement. Furthermore, statutory information that's required on a citation, such as the court's date and the location and time, has to be put on the citation at the time of issuance. It was all missing. And later, 12 days later, additional information was put in the document fraudulently, and it's considered tampering with a government document and evidence. And so the citation on its face and these other issues about fraud invalidated.
Well, we're dealing with local government, small rural county government, and it's very notoriously indifferent to the statutes and to due process requirements. Somehow, it's too much details for these people to deal with, Jay. But the main thing, I think, aside from these numerous felonious faults, one of them is a felony. More significant than those is the possible transformative analysis that you've made regarding the exhaustion of administrative remedies. What does one of the cases say that you're citing in your paperwork? You had roughly about an 8-page motion. You had about a 10-page, 9-page notice of the law. What does the case say? I'm trying to remember. It's not Ready Mix. It is the.
Well, they have McMinnville Freight Line. They have Hoover. They have Reeves versus Owens.
Right, the Reeves case.
And
yes.
then they have Hodges versus Jones. Numerous cases. And what they all say is that the legislature has provided for an administrative procedure whereby privileges such as driving and licensing and so on, if there's a contested case, they're to go before a hearing officer. And the administrative remedies have to be completely exhausted and everything finalized at the administrative level before it can then be taken to a court for a judicial review. And heretofore, that's never been done. They always immediately, after writing a citation, for instance, goes right to the traffic court, rather than going to the Department of Safety, for instance, up in Nashville.
So your thesis, Jay, is that this court doesn't have, the criminal court doesn't have subject matter jurisdiction because the petition by the state is in the wrong court. The state is trying to enforce its privilege law, which is administrative, and that privilege oversight is by the commissioner of which department?
Department of Safety and Homeland Security.
So Jay Hirsch is the Nome Emeritus in Tennessee for a reason. That's because he, more than any other legal beagle, any other victim of the police state, has made the discerning analysis, and that is on privilege. The defense starts with privilege, and that's the argument we're making here, and we'll be hearing a little bit more from Jay. He is a man of great reading, great knowledge. We read cases together.